Good afternoon and welcome to the Longshore Situs webinar. This is the third in the series of 3 regarding longshore insurance. The first one was rules and regulations, the second one status, and this one Situs. Where did the accident happen? Remember, as we talked about, that you require both status and situs to become eligible for benefits under Longshore. As such, if you fail one of the tests, there's no point in going on and doing the other test. Personally, I find Situs a slightly easier test, even though it can be somewhat confusing with the different districts. So I tend to do this first. It really doesn't matter which one you choose first, as long as you do them separately. If you start blending the two together, you're probably going to come up with the wrong answer. So let's move right into Situs. Except as otherwise provided in this section, compensation shall be payable under the Act in respect of disability or death of an employee, but only if the disability or death results from an injury occurring upon the navigable waters of the United States. Now, some additional wording about adjoining areas, which we'll come to a little later in this webinar. But let's focus first on what are the navigable waters of the United States. The Coast Guard will have a definition. The government has a second definition. But from the point of view of Longshore, we have to have a working definition which we can use. It's very fact specific, and one employee may be on the navigable waters of the United States one day and off the next. But it's where does the accident happen is so critical. Here's the best working definition we can give you. It's when directly or indirectly travel to another state, country, Gulf of Mexico, or ocean. Even if it's not currently navigable, and extends 12 nautical miles, about 13 and a bit land miles, out into the ocean and into the Gulf. There's no requirement for waterways to have any commercial activity on them, as long as there's some sort of activity. It's likely that if there's no activity, there's really no work going on, so that does limit the options. Most of this is pretty obvious. The coastlines, the Gulf, the Atlantic and Pacific coastlines, and now the territories are pretty obvious places where Longshore comes into play. But it's this directly or indirectly to another state often confuses people. Let's take, for example, Lake Tahoe. Lake Tahoe forms a border partially into California, and partially into Nevada. So on Lake Tahoe, even though it's landlocked lake, you can travel directly to another state, and therefore it's Longshore. Clearly, places like the Mississippi rivers and all its tributaries are Longshore. Down here in Florida, Lake Okeechobee is a longshore location or longshore situs because the intercoastal waterways run through it, and even though you have to go through a number of locks, you can get out either to the Atlantic Ocean or ultimately to the Gulf of Mexico. Even if it's not currently navigable, it still makes it Longshore. It really has to be completely removed from navigation before Longshore Situs stops. What's not navigable waters of the United States is a landlocked lake or upstream on a dam on a river with no locks to bypass, wholly within a single state. It's not the Coast Guard. It's not the Coast Guard that determines this. It's the facts of the actual claim and where the claimant's injured. And again, that landlocked lake has to be wholly within the state and with no real way in or out of it, so you could get to the Gulf or to the ocean. One of the best examples into the Magic Kingdom in Orlando, you had the opportunity to ride a paddle wheeler across to the main entrance. That's on a lake called Lake Buena Vista. It's entirely landlocked. There is no way in or out of it, save some underground streams which don't count. But of course the courts don't leave it there. They take that 12 nautical mile boundary and extend it further out for vessels sailing directly between 2 US ports. Cove Tankers was the first case in this It was a vessel that was sailing from Philadelphia to New York and was 200 miles out when a boiler exploded, killing one person, severely injuring a second. The court quite reasonably said that you just can't avoid longshore coverage by sailing more than what was then 3 miles outside. And I sort of understand, but when you look at Colares versus DG Marine Maintenance, that vessel was sailing from Galveston, Texas to Long Beach, California with no stop or voyage in foreign waters. It was going around the Cape to come back up to Long Beach, California. I don't know how far that is, maybe 10,000–15,000 miles, but it's certainly a lot more than the 12-mile limit which the government originally imposed. This can even be sailing back to the same port. So if you left maybe Miami, didn't go to any foreign ports or any foreign waters and returned to Miami, the longshore exposure would still be there. For those of you who may have heard this particular seminar before or heard us live in one of the many seminars we give around the country, we've talked about longshore being granted overseas. First in Weber versus Loveland out to Jamaica, in Grenham versus Alley out to Russia, and in Keller versus Tracy. But there's been a recent court decision that's actually overruled that. Wiley versus Orion Marine Construction. In 2014, Wiley fell whilst he was in navigable waters of the Dominican Republic, whilst he was attempting to cross a tug to a barge. The court actually finally read the words of the Longshore Act and said, this is navigable waters of the United States. It can include high seas, such in the last couple of cases we looked at, but it does not include foreign territory. So whilst Wiley was injured in Dominican Republic, he could no longer meet the Situs test of longshore. Again, remember, if they were on the high seas, he could have done, but just because he was in foreign territorial waters, he could not. But of course, the law doesn't leave it as navigable waters. It includes any adjoining pier, wharf, dry dock, terminal, building way, marine railway, or other adjoining area customarily used by an employer in loading, unloading, repairing, dismantling, or building a vessel. So what's an adjoining area? It's a very complicated rule because we've got a lot of different precedents set by the Department of Labour in different parts of the world, by the court cases that the Department of Labour interpret. This is so confusing that the Department of Labour issued their own bulletin 1402 in 2014 that look at courts across the country and outline the precedents in those courts. Remember though, this is where the accident happened, not where the employee was hired, lives, or have a place of contract. So if we, for example, have an employee in California who travels to Texas to work, moves from the 9th Circuit to the 5th Circuit, and the 5th Circuit rules apply. 7 states, Louisiana, Texas, Mississippi, West Virginia, North and South Carolina, follow a case called Sidwell versus Container Services. And they interpret to mean lie next to, be touching or bounding at some point. That's a relatively easy test. Can you draw a line that says, I'm touching or bounding navigable waters? If you're right next to the river, such as the Mississippi there in Louisiana, then clearly that's going to pass. But if your area is removed from adjoining the river or the Gulf, then Situs will fail. 16 states listed here in the slide talk more about the function of the site, the suitability of the site for maritime uses, the proximity of the water, were the adjoining premises used in maritime commerce, was it as close to the water as feasible? This is a much more complex test and has led to a case up in Maine where the Situs was given 2 miles inland because it was as near as possible maritime location and was used exclusively in the production of steel plates for a shipyard. 3 states, Florida, Alabama, and Georgia, use case law from Texas Stevedores versus Winchester. Adjoining means close to, near, or neighboring. Now this is not next to, but close to. So this takes in a wider boundary in these 3 states than you would see in our first group set of states, but does not have any functional test as you'd expect as you saw in the second set of states. The third circuit is very confused. 3 states here use both Heron and Winchester as precedents, so you can really choose both to go along. And all other 21 states haven't used a precedent, so the Department of Labor are using Heron as the test in those. Again, remember, this is where the accident happens, not where the employee is hired or is paid. Here's a flow chart that we put together now 20 years ago that really goes through the questions as to how do you choose when a particular claim is eligible for Longshore or not. But we have an easier way for you to do that. Under the Longshore toolbox, you'll see here a link to a site called the Longshore Factor. And that goes through the various questions. As to whether somebody is in the correct situs or status, and gives you an opinion based on the input you put in there as to whether the employee is state act, is Longshore, or for some matters are maritime or admiralty employees. It doesn't have, it would be impossible. So you have to look back at the last few slides to determine where did the accident happen and was I in situs. Clearly, if you're right next to the water, situs is going to apply, but the further away you go, the more it will depend on the jurisdiction in which you're working. Situs plus status equals eligibility. No situs, you can't be eligible. No status, you can't be eligible. Only both succeed. Thank you very much for your time this afternoon.